first case on this morning's docket. That is case number 109985, State of Kansas v. McCormick.
Good morning. May it please the court, Christina Curls of the Appellate Defender Office for Mr. McCormick. Request 3 minutes for rebuttal.
3 minutes is granted.
I'd like to start on the first issue of this brief, but I'm going to touch on all three of them, time permitting. The first issue regards evidence that was admitted over the objection of counsel. In this case, Mr. McCormick was charged with rape of a 13-year-old BP. Also present in the basement of his friend's house was BP's friend Casey. And the evidence that was challenged was testimony from Mallory Zavala describing Casey's condition when she arrived at the basement. She described that Casey was passed out and that she was naked from the waist down with her vagina showing. This was objected to as relevance since Casey was not a claimed victim in regards to the rape. The Court of Appeals found that it was relevant and admissible because Mr. McCormick was also charged with hosting minors drinking alcohol. Therefore, the fact that she was passed out was probative to that count. And we would agree that the fact that Casey was passed out could be probative to the other count, but there was nothing about the fact that she was naked from the waist down with her vagina showing that would be probative to hosting minors drinking alcohol. And therefore, that part of the evidence was not relevant and should have been excluded.
Counsel, assuming that to be true, my understanding is that your client admitted to this act. Is that right?
Well, I reread that portion of the testimony that at some point he did tell the police that he had sex with BP. The police officer was asked, did you go into detail as to what that meant? And the police officer said no. In this case, there was also fluid found on the outer part of BP's vagina. And we would argue that while there is evidence to support that a rape occurred, which was one of the reasons we didn't raise sufficiency, it's not so overwhelming to make the admission of this other evidence harmless error. That there was evidence that the state cannot overcome the burden of proving that there's no reasonable possibility that the verdict could have been different based upon the nature of the evidence that did come in.
It's further my understanding that the fluid on the victim contained your client's DNA. Is that right?
It did, but I also think that it's important as to where the fluid was found. It wasn't found, it was found on the, no, I'm not going to pronounce this right, but the labia, the majora, and minora, which doesn't necessarily indicate penetration. If it was found inside, then it would be a harder argument, but it would be possible for the fluid to be found where it was if there was no actual penetration. So we would argue that while there is evidence that could support the rape conviction, it's not so overwhelming for the state to be able to overcome its burden to prove beyond a reasonable doubt that the error was harmless. Yes.
On the issue of KC
yes.
and all that, how does this argument get you anywhere? And the reason I ask is because in looking at the transcript, the way the trial evidence came in, we have a question about KC's description. Can you describe how KC appeared? Answer, she didn't have any pants on. No objection. Okay, when you say she didn't have any pants on, can you tell us what you mean? She was naked from the waist down. No objection. Okay, she didn't have anything on at all. Again, no objection. Were you able to see her vagina? If you stood in front of her, yes. Again, no objection. Before you get to the objection in this case, all of this stuff's already in. So how do we do anything with this?
I would agree that the objection was later than would be optimal, but I would still argue that it was soon enough and specific enough, given the fact that he objected to the evidence relating to KC, as she was not a victim, that while it would have been optimal for it to be several questions sooner, I would argue that it still satisfies the contemporaneous objection rule, that if the district court had ruled that it was irrelevant,
I'm
he
less
could have
concerned
instructed the
about
jury to disregard.
contemporaneous objection than I am just all of this, all the information that you say is prejudicial is already in the evidence without an objection. And, you know, and so there can't be, I mean, I don't see how we would get to reversibility even if we agreed that the specific question that was objected to, you know, should have been sustained as, you know.
Well, I would argue that given even though he objected to what I would argue is probably the least damaging of that line of questioning, his objection, at least to me, appeared to be to the line of questioning, not just to that last question.
In which case he's too late.
Well, I mean, I would argue that given his objection and the fact that he objected to relevance to this information regarding KC, that the judge, the district court could have granted sustained the objection and instructed the jury to disregard the evidence relating to Casey's condition in the basement.
But there wasn't a motion to strike anything that had come in already.
There wasn't, because he lost the objection. I mean, if he had won the objection, I would hope there would have been a motion to strike that followed that and a request for an instruction for the jury to disregard. I do agree that it would have been optimal if he had made the objection several questions sooner, but I think that given the wording of his objection, that he objected to the evidence regarding Casey because she was not a victim in this case, that it can be, that it applies to this line of questioning regarding Casey.
Why isn't the sexualized, let's say, pose and repose of KC, why is that not relevant to a rape case?
Because he wasn't charged with anything relating to Casey.
Not charged with a sex crime. He was charged with supplying or assisting in supplying these two minors with alcohol.
I don't know specifically if there was a supplying, but hosting minors drinking alcohol is what.
Yeah, he admitted to the police that he was involved in the procurement of the alcohol. He was a conduit.
Well, I would.
Why is it not part of the much maligned res gestae of the crime? Wasn't BP in the same room?
She was in the same room, but I don't think that there's anything about the fact that KC was naked from the waist down that has anything that in any way is probative to whether or not Mr.
What's the definition of relevance? It makes it more probable than it would be without the evidence. And
Yes.
You're saying there were two, 19-year-old boys and two 14-year-old girls.
I believe they were one of at least BP
anyway,
was 13.
two younger girls
Yes.
were in the basement drinking, and there was evidence that one of the girls was in a posture that appeared that sex had occurred, or very likely. Why doesn't that make it more probable that sex occurred between defendant and BP than if there was not that evidence?
Because there was never any allegation that Mr. McCormick had sex with Casey, and that sort of inference.
Well, we're not talking about case with KC. We're saying, why isn't it more probable that he had sex with BP if there was sex going on in the basement among other people? I mean, relevance isn't proof of the crime. It just makes it more probable that fact is true, right?
That is true. I think it's a leap that just because someone else was having sex in that basement means that Mr. McCormick was having sex in that basement. And the issue with this is that there wasn't any evidence that came in that the friend had sex with KC. So the problem with this evidence is it led to the inference that Mr. McCormick was the one who had sex with both of these. I'm sorry, what?
Stacking inferences?
Right. I mean, and the argument does go more to the prejudicial effect of it. That it would allow the jury to conclude that Mr.
That's a different question, though.
That's a different question from relevance, isn't it? Yeah, why do you get to raise that at this point, given that the objection at trial was limited to relevance?
I would argue that a prejudicial analysis kind of goes hand to hand with relevance, particularly given the nature of the evidence and the objection that was made. That, I mean, yes, it was just straight up an objection to relevance. The attorney did not argue prejudice, but the nature of the evidence that came in and the fact that he argued that Casey was not the victim in this case, to me, there's an implicit argument that because Casey was not the victim in this case, this evidence relating to Casey would prejudice the jury.
Getting back to Justice Byers' point, why isn't it just relevant for the hosting of a minor and consuming alcohol? Why? I don't understand why the physical condition of KC is not relevant. And part of her physical condition is she was naked.
I would agree that the physical condition that she was passed out would be relevant to the fact that she had drank alcohol. I don't see anything about the fact that she was naked from the waist down that would be relevant to
Passed
show that
out
she
naked
drank.
doesn't add to the relevancy of, or doesn't add to the charge of hosting a minor.
I don't think the fact that she was naked from the waist down adds to that. I don't see how someone being naked from the waist down is evidence that they drank alcohol.
Except in our nightmares, we generally don't walk around without pants. Wouldn't you agree?
I do agree, yes.
So isn't the fact that she's not wearing clothing probative of whether she was drunk?
I don't.
She
Given
wouldn't do that
the,
if she weren't drunk. Would she?
given the
I think the
totality.
jury's common experience is that people don't do that if they're not drunk, right?
Well, I would say given the totality of the evidence in this case and the actual circumstances that were going on in the basement, what was more likely to have occurred is that Mr. McCormick's friend who was down there removed Casey's pants and underwear, and it's not necessarily probative of the fact that she was drunk. It's probative of the fact that something happened to her, and he was charged with a separate crime for that. But the fact that this evidence came in Mr. McCormick's case allowed an inference that Mr. McCormick did more than what he was actually charged with. And that's why we're arguing that the district court erred in admitting that evidence. And just to touch, unless there are further questions on that issue, I just wanted to touch briefly on the other two issues. I submitted a 609 letter regarding State v. Jolly relating to issue 2, and I would just ask the court to follow the...
Go ahead.
I was going to ask the court to follow the ruling in State v. Jolly, and that in this case, given the fact that the district court said that but for this aggravating factor it considered, it likely would have granted the departure.
So it trumped the mitigators. I just want to make sure I'm clear on how that sentencing came down. There were two different types of departure under consideration.
I believe so, yes.
The dispositional from, or I don't know whether we call it dispositional, really just downward from
Right.
Jessica's law to the grid, and then the second one was the grid to a durational off the grid
Yes.
range, right?
I believe so, yes.
Okay, and you're saying, so your argument is that Jolly controls on the departure from the Jessica's law to the grid,
Right.
and that was what was performed incorrectly because the judge applied the wrong legal standard.
Yes.
That's where the abuse of discretion really lies on that departure.
Yes.
Okay, thank you. I understand.
Counsel, before you sit down, could you summarize for our audience what the sentencing issue is and describe perhaps a little bit about Jessica's law?
Yes, Your Honor. In this case, a Jessica's law life sentence with no possibility of parole for 25 years was imposed because the defendant in this case was over the age of 18, but the alleged victim, BP, was 13 years old at the time of the crime. So the mandatory sentence for a first-time offense is life with no parole for 25 years. In this case, Mr. McCormick filed a motion to depart from Jessica's law to impose a guideline sentence.
Which would be lower.
Yes, which would have been lower because I believe Mr. McCormick didn't have any other criminal history. So it would have substantially decreased his sentence. And I believe that there was another departure motion filed to decrease further from the presumptive sentence on the grid. The issue in relating to issue 2 is the statute allowing for a departure from Jessica's law allows the court to consider mitigating factors. It says that the district court shall impose the presumptive sentence unless it finds substantial and compelling mitigating factors to depart from the Jessica's law sentence. What happened in this case is that the district court found several mitigating factors, but also found one aggravating factor, that BP was intoxicated at the time of the crime, and found that that aggravating factor overruled the other mitigating factors, so denied the departure. This court has previously found in State v. Jolly that the plain language of the Jessica's Law departure only allows the court to consider mitigating factors and not do a balancing of aggravating factors. So we would argue that the district court erred when it imposed or when it denied the departure to, or I guess as relating to issue 2, it erred in considering the aggravating factor and weighing that against the mitigating factor and considering his departure motion.
And what you're asking for is for a remand so he can be resentenced?
Yes, Your Honor, a remand for resentencing, particularly in this case, given the fact that the district court indicated it would have granted the departure but for that aggravating factor.
Very well. Any more questions?
Yes,
Go ahead.
Yes.
the aggravator wasn't just that she was intoxicated. The judge spoke to the extreme intoxication and her inability to recall anything.
Yes.
Correct? And, well, that's fine. Thank you.
Thank you, counsel.
Thank you.
May it please the court, Kerwin Spencer, County Attorney for Sumner County, appearing on behalf of the state of Kansas. I was not the prosecutor that presented this case. I've taken office since then, but I have in fact reviewed the transcript that was involved. I would note that the transcript does mention that there in fact was a videotape of the defendant's confession. So I hope the record has been complete so that that videotape is available to you. And that is relevant as it relates to whether or not the evidence is overwhelming on the third sub-issue under the first issue. That is, if there was any error, it was harmless error because the evidence, in fact, was overwhelming. We have a rape kit exam, the defendant's DNA on part of the victim's vagina, and that, a confession. It is true that the victim was intoxicated to the degree that she did not have a recollection, or at least testified she had no recollection of the actual rape occurring.
Counsel,
yes.
Let's just get on the sentencing issue because we were just talking about that. Do you concede that this case has to be remanded back for resentencing because of the aggravating factor?
No, Your Honor. Looking at State v. Jolly, first of all, the trial court never concluded that the circumstances found that were mitigating were sufficiently compelling to demand a departure. So, they have to be not only substantial, but have to be compelling.
That goes to the weight of the mitigators but didn't the judge apply the wrong standard by considering aggravators at all under Jolly? On the first level of departure, the one having to do with downward from Jessica's Law to the grid.
Okay. While KSA 214643 does not allow the weighing of aggravating factors against mitigating factors, the facts of the case, including any egregious ones, are essential for a judge to consider in deciding if a departure is warranted based upon substantial and compelling reasons. That's mentioned in the Jolly case starting at 324, the compelling parts at 323. And then at 324, it goes on to say that the sentencing judge is to consider information that reasonably might bear on the proper sentence for a particular defendant, given the crime committed, including the manner or way in which an offender carried out the crime. Now this includes, and I quote, circumstances inherent in the crime and the prescribed sentence. Now we really need this court to carefully define what is meant by the circumstances inherent in the crime, because that is crucial in deciding whether or not there was error made here or not. Here, Judge...
Counselor, before you go on with that, can we clarify? I've got a quote up here that Judge Mott said, quote, even though there are some substantial mitigating factors, I think it's just trumped by the evidence that this particular 13-year-old was severely inebriated to the point where she couldn't give consent. And so he goes on to say, so I haven't heard anything that makes me think I should go ahead and find substantial and compelling reasons to depart. And so I think we need to look at this in the context that the judge verbalized that there was this circumstance, even if you don't call it an aggravator, that trumped what he considered to be substantial mitigating factors.
So, Your Honor, what I'm saying is that the trial court obviously made a mistake in calling that an aggravating circumstance. But the issue is whether or not the court calling it an aggravating circumstance in fact makes it an aggravating circumstance rather than a circumstance inherent in the crime. If it's a circumstance inherent in the crime, then the court calling it the wrong thing is not an error that requires reversal. But if you decide that that's not a circumstance inherent in the crime, then I agree that it would have to be reversed for resentencing. Now here Judge Mott commented that he found certain things to be mitigating factors and other things not to be mitigating factors. Then he noted that there's an aggravating factor here. That's the unfortunate terminology that the judge used. And then he described that as sexual intercourse with an unconscious 13-year-old. Then he commented at page 14 of the transcript, both girls were extremely intoxicated. Both were found in the basement without underwear on. Neither girl had a recollection of the sexual intercourse, which is evidence they were passed out while the sex happened between the defendant and his victim. And then he goes on, I think that even though there are some substantial mitigating factors, I think it's just trumped by the evidence that this particular 13-year-old was severely inebriated to the point where she couldn't give consent.
Counselor, let me stop you right there. What difference does it make whether she had consented? By law, she can't give consent.
Exactly. Exactly. But the fact that there is literally no consent, besides legally no consent, might be or probably is, and it's our position that it is, a circumstance inherent in the crime. For instance, if this were a forcible physical rape, which is another subcategory, using force or fear, I submit that that would be a circumstance inherent in the crime that the court could be allowed or should be allowed to consider in deciding whether or not other mitigating factors in fact amount to compelling. Because again, it's got to be not only substantial, but it's got to be compelling as well. The trial court concluded that the mitigating factors were not compelling when he said, I haven't heard anything that makes me think I should go ahead and find substantial and compelling reasons for departure, so I deny the motion. So it's not, sometimes we think of those substantial and compelling as being just substantial, okay? They have to not only be substantial, but have to be compelling. And, it's mentioned in the Jolie case, what compelling means as well. Unfortunately, the court said in describing that the sex was with an unconscious, severely inebriated 13-year-old female, that but for this aggravating factor, I would tend to grant. Of course, that tend was, you read the transcript, the word tend is in there, okay? And appellant leaves out the fact that tend to grant is in there, okay? He doesn't say, I would grant, he says, I would tend to grant. So that's, again, some evidence that he never found that those mitigating factors were compelling.
Mr. Spencer, isn't that a critical point, though? Because even if we agree with you that all of these circumstances are those circumstances that we would call as inherent to the crime that the court is allowed and should consider, if the judge was under an understanding that that aggravating factor prevented the exercise of discretion in essence, doesn't that just change or shift the way the court was weighing the circumstances enough to make us say we've got to start over with this with the judge understanding how the formula works?
I don't believe so, because he he did not, one, conclude that they were compelling, and two, he said that, you know, if this were an aggressive 13-year-old and everyone's not drunk, I can see granting this. So what the court needs to, what this court needs to decide is if Judge Mott merely made a semantic error in calling how the sex occurred as an aggravating factor. You know, if you would expect him to consider how the sex occurred as a inherent fact in the crime, then the mere fact he called it an aggravating factor gets us back to the fact that he never found the other mitigating factors as being compelling. So,
I think.
and he didn't, what he analyzed was that those other factors did not overcome this factor that's inherent in this crime, that being that the girl was intoxicated to the point where she could not only not legally consent, but could not literally consent as well. So I submit that, you know, this is an aggravating factor would be something like, well, he's misbehaved in some other way, unrelated to this, or his prior record is such that he doesn't deserve another second chance, or of course that might keep the one significant, compelling, not compelling, but sufficient, the underlying, I forget the word right now, but substantial. The one substantial but not compelling was that he didn't have any significant prior record, no prior record. So he considered that, and he considered some other things that were potential mitigating factors. I think it's clear that he considered that the lack of any record was a substantial reason to consider that, but it was not compelling based upon this other circumstance, which if you decide this other circumstance is properly inherent in how the crime was committed, then his analysis should not be reversed, and we should not need to have it remanded.
Let me talk about something more fundamental. What we call Jessica's Law is an enhanced sentence, isn't it? It's an aggravated sentence to start with.
Yes, because of the age of the child.
Well, and so why do we need to consider aggravating factors? Because there's no place to aggravate this or enhance this sentence. How do you aggravate an aggravated sentence, and how do you enhance an already enhanced sentence? And so why are we even looking at the factors that are bad factors, because that's already been part of the enhanced sentence? You understand? I mean, there
Yes,
seems to be a
do.
very real reason for me why the statute doesn't refer to aggravating circumstances where others do, because you're already there. You're already enhanced.
Well, and there could be other potential aggravating situations that you clearly wouldn't want to get into. You wouldn't want to get into, well, there were, two victims of this defendant. You would not want to get into that. Anything that is not inherent in how this crime was committed, you would not want to engage in any balancing. And it's not that you really are balancing an aggravating factor, it's that you consider how serious this crime is in deciding if any of these mitigating factors are in fact compelling. And I also want to underline that determination of compellingness is a determination to be made by the trial court. It's not, shouldn't be made by the Court of Appeals, as in Jolly, which was then reversed by the Supreme Court. We, entrust our trial judges with with substantial, discretion. Our system benefits from the opportunity to have the insight and wisdom of the trial judge as it relates to explaining things. So we, at least on this issue, got to have the court explaining itself and how it arrived at this. Now, the Jessica's Law case doesn't require the court to explain why it makes its decision, but our court here did explain why. We have to explain our decision if, in fact, the court finds substantial and compelling reasons. Then we need to put on the record why the court found what was found. So, our court went further here than what was required. The court would have just, said, I've considered all those things. None of them are compelling. I'm denying the motion. We wouldn't be here today.
Yeah, we wouldn't be here, but one of our abuse of discretion tests is whether the court applied the correct legal standard. And I think that's what we're struggling with now. Mm-hmm. If the court balanced aggravators versus mitigators, that's not the legal test that we have here, correct?
Right. The legal test should be whether or not the crime as committed here was overcome by the mitigating factors.
Right, and even though the judge did not have to explain why he denied the departure, if that explanation indicates that he used the wrong standard, even though we're very deferential to the trial courts, we have to send it back and say, do it correctly, and you can use your discretion, don't we? And so it really hinges on whether we think the trial judge applied the correct legal standard.
Yes, but inherent in that, it's whether or not you think that what the judge pronounced, as the judge mistakenly called it an aggravating factor, is an inherent part of the crime. If it's an inherent part of the crime, then it's a valid consideration, which, in order to be overcome, the court has to find the mitigating factors are in fact compelling. And I submit that he never found they were compelling. And I know I'm about out of time, but the wisdom and insight of our trial judges is a judicial resource that our criminal justice system should take advantage of whenever possible. Our trial judges do make mistakes from time to time and need correction, but when the issue can be presented to the trial judge, the judge can at least explain his decision and have an opportunity to prevent error. When an issue comes directly to this court, as did the issue of whether or not, in the first issue, whether or not the testimony having to do with the state of undress of the other girl that was there, without the benefit of being presented to the trial court, then we lose the opportunity for the wisdom and insight of the trial judge, in particular as it relates to whether or not that was in some way prejudicial evidence, prejudice being, or the probative value being overcome by prejudice, is an analysis you only get to in basically 6455 evidence. You don't really get there under 6445. And so I would just ask you to consider that as it relates to that first issue, which I did not spend very much time on.
Do we have any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
The facts inherent to this crime were the fact that there was sexual intercourse with a person under the age of 14.
Is that what that refers to? Does it refer to, that was going to be my question to you. Is it the crime that was committed or the manner or way in which the offender committed the crime?
I would argue that it's
pretty significant distinction here.
Yeah, I would argue that it's the crime that was committed, the elements of the crime that was committed in the crime of conviction.
And that's what talks about the circumstances inherent in the crime, doesn't go to the manner.
That is what I would argue, because anything else is something outside of the crime that could be an aggravating or mitigating factor. And I guess what I would argue to support that is if you do look at the list of aggravating factors in other statutes which allow for the weighing of aggravating factors, in those are the manner in which the crime is, in some of those are the manner in which the crime was committed. So I would argue that in Jolly, the facts inherent to the commission of the crime are the actual elements, the facts necessary to prove the crime, and anything beyond that would be an aggravating factor. So the fact that the facts inherent to this crime were the fact that there was sexual intercourse with a 13-year-old, the fact that she was intoxicated, where the judge found she was intoxicated past the point of giving consent, would be an aggravating factor, and that's exactly what the judge called it in this case. I also think it bears mentioning that the state's position here today is different than it was in the district court. At the district court, the state said the departure to the grid was appropriate. It's on page 7 of the sentencing transcript. The state agreed the departure to the grid was appropriate. It didn't join or oppose the departure, downward duration departure from there, but at sentencing, it did argue the departure to the grid was appropriate. And we would argue that based upon Jolly and the fact that the district court applied the inappropriate legal standard, that this case should be remanded for resentencing. Primarily that his conviction should be reversed, but in the alternative, it should be remanded for resentencing.
The state joining in the recommendation, or the first part of the recommendation for departure, was not part of a plea agreement, was it?
No, because it went to trial.
So what do we make of that? I mean, what's that got to do with whether the trial court applied the correct standard?
I don't think it has anything to do with whether or not the trial court applied the correct standard or not. I would just say that it is significant that at trial, the state agreed that the circumstances indicated that a departure to the grid was appropriate, and the argument is different here today.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.